Hi students, the last chapter in company law, very important chapter, winding up of a company. What is winding up? Winding up is the closure of the company. It is the last stage in the life of the company. In this stage, what will happen? All the assets of the company will be sold and the liabilities, that is outside liabilities, will be settled out of the assets sold. Then the shareholders, the amount of the shareholders will be settled. Finally, if there is any surplus, it will be distributed to the shareholders. Otherwise, the company will be closed. For this purpose, a special person is appointed who is called as the liquidator of the company. He takes all the necessary work relating to liquidation of the company or winding up of the company. Winding up is also called as liquidation of companies. The next aspect in winding up is modes of winding up or types of winding up. There are two types of winding up. Number one is winding up by tribunal and number two is voluntary winding up. Winding up by tribunal is compulsory winding up. It is a winding up by the order of the court or tribunal. Whereas voluntary is on the own mode, by the own decision taken by the shareholders and the creditors, the company will be wound up. These are the two types of winding up. Now we will see the types of winding up in detail. Now let us see winding up by tribunal. What is winding up by tribunal? It is the winding up made after receiving an order by the company law tribunal, that is a national company law tribunal, to wind up the affairs of the company. It is also called as compulsory winding up. In this winding up, a special resolution is passed. A general meeting is called and a special resolution is passed. Then the steps were taken for winding up by tribunal. What are the reasons for compulsory winding up? Why the company law tribunal gives an order to wind up the affairs of the company? The following were the reasons. Number one is the inability to pay its debts. If the company is not able to pay the debts more than rupees 1 lakh, then the tribunal will order for winding up. Then if the company was declared as a sick company, that is the company which is not able to rehabilitate or revive, then it is called as a sick company. Then the tribunal will order for winding up. Then next one, the reason is the default in filing the financial statements for continuous 5 years. That the financial statements of the company must be filed every year to the ROC. If for continuously 5 years the financial statements were not filed, then the tribunal will order for compulsory winding up. Then next one is fraudulent trading. If there is any fraudulent trading is going on in the company and if any complaints were received by the tribunal, then the tribunal will order for compulsory winding up. Then just and equitable situations. That is just and equitable clause. That sometimes the company law tribunal will think that this is the just and equitable situation. In this case, the company must be wound up. The reasons for just and equitable were, if the company is suffering from continuous losses, the company will be wound up. The tribunal will order for winding up. Then if the minority views were suppressed, then if the company failed to achieve its objectives, then the tribunal will order for winding up under just and equitable clause. These were the reasons for compulsory winding up. The next one is the procedure for compulsory winding up. Then if the court or the tribunal order for winding up, what is the procedure? First, the submission of the petition to the tribunal. Then the petition is submitted to the tribunal. Petition is the application. Next, filing the copy of the petition with the ROC. Then the application must be filed with the ROC. Then the commencement of winding up proceedings. Then commencement of winding up proceeding is the liquidator is appointed and he will start with the proceedings. Then the advertisement of the petition, then the advertisement is given in the newspapers that the company is going to wound up. Then the decision by the tribunal to wound up the company. Then intimating to the ROC and the liquidator of the company about the winding up. Then filing the winding up order with ROC. Finally, the company will be closed and the winding up order will be filed with the ROC. This is regarding the procedure for compulsory winding up. Next mode of winding up, or the next type of winding up, it is voluntary winding up. Voluntary winding up is on the own mode. The company will wind up its affairs without interference of the tribunal. The object of this winding up is that the creditors and the members, they can settle their affairs without the interference of the court of law. A company may wound up by passing an ordinary resolution or special resolution without interference of the court. Then after passing the resolution, within 14 days of the passing of resolution, the company shall give the notice of resolution by advertisement in the official gazette of the registrar of companies and in some leading newspapers circulating in the district where the register office of the company is situated, to make know about the winding up of the affairs of the company. The procedure regarding the voluntary winding up is: number 1 is ordinary or special resolution must be passed. Then number 2 is the declaration of solvency must be filed with the ROC. What is declaration of solvency? That the directors have to give a declaration that the company has no debts, and if it has debts, it can be paid in full out of the assets of the company. The declaration must be made within 5 weeks of passing the resolution, and the copy of the declaration to be filed with the ROC. Then the third step is the appointment of the liquidator. The liquidator will take care of the winding up of the affairs of the company. Then fourth one is the board's power ceases. That is, on appointment of the liquidator, the director loses their power. Then the notice of the appointment of the liquidator must be submitted to the ROC within 10 days of appointment. Then the liquidator every year will call a general meeting of the share members and the creditors. Then the duty of the liquidator to call the creditors meeting every year regarding the settlement of the creditors. Then after that, final meeting will be called by the liquidator and the affairs will be settled. This is regarding the provisions regarding voluntary winding up. The next aspect in winding up is petition. Petition is application to the court for winding up of the company by the following persons. Who are the persons eligible to give application for winding up? First one is by the company itself. Number 2, by any creditors of the company. Number 3, by any contributories of the company. Contributories are the shareholders. They will be named as contributories at the time of winding up. They contribute to the assets of the company, so they are called as contributories. Then next one is by the ROC. Then by all or any of the prior parties, that is the company and the creditors, the company and the contributory, or any one or two, they can join together and give a petition. Then by any person authorized by the central government. The petition must contain the information relating to the name and address of the company, the date of incorporation, the paid up capital, the statement of the facts to justify the winding up order, the reasons for winding up. This is regarding petition. Next one is the liquidator. Liquidator is a person who takes care of the entire winding up proceedings. He is appointed by the company and the board's power ceases on appointment of liquidator. He is entitled to a remuneration. His main duty and function is that to settle down the assets of the company, to sell the assets of the company and settle down the liabilities and make a final closure. What the duties of the liquidator? It is a very important aspect. Duties of liquidator. First one is duty to take care of the proceedings and winding up. Next one, duty to submit report to the tribunal. Duty to submit any further additional reports required. Next, he must act as a custodian of the company's properties. Next, he has the control over the entire assets of the company. The duty to call general meetings, duty to call creditor meetings, duty to maintain proper books of accounts, duty to audit the accounts, duty to have the control of his powers over the assets of the company. This is regarding duties of liquidator. The next aspect is the powers of the liquidator. The powers can be divided into two. One is with the sanction of the court. Number 2 is without the sanction of the court. With the sanction of the court, the powers of the liquidator. to institute any civil or criminal suits in the name of the company. Next one is to carry on the business of the company for the benefit of the winding up of the company. Next, to sell the movable or immovable properties of the company. Next one is power to raise money on security of the company. Next, power to do all other things necessary for winding up. Next, appoint any advocate for his assistance. This is regarding the powers of the liquidator with the sanction of the court. Next, powers of the liquidator without the sanction of the court. Number one is to do all acts on behalf of the company under its common seal, to inspect the records and returns of the company without paying any fees, to draw or accept any bill of exchange or promissory note, to appoint any agent, to do any act for himself. This is regarding the powers of the liquidator. Next aspect is the consequences of winding up. Consequences is nothing but the results of winding up. Because of winding up, what are the consequences? Number one, consequences as to shareholder. Shareholder is a person, he is liable to pay the full amount of the shares held by him at the time of winding up. So you want to settle the full amount at the time of winding up. Next, consequences as to creditors. Creditors, they want the settlement from the company, so it is in the order of priority. First, and secure creditors will be settled. Next, preferential creditors, that is rent, salary, wages, like that. Next, debenture holders, that is a secured creditor. Then unsecured creditors. These are the order of preference of payment in case of creditors. Next, consequences as to employees. Employees, in case of winding up, they want to discharge all their duties and responsibility as an employee. Next, consequences as to cost. If the assets are not able to satisfy the liabilities, then the court may order for payment of expenses of winding up out of the assets, and the payment must be in the order of priority, like preferential creditors, like that. This is regarding the consequences of winding up. The important questions in this chapter is define winding up, explain its modes, the petition, next duties and powers of liquidator, next one is the consequences of winding up. This is regarding the last chapter in company law. If you are interested in my channel, in my video, you can subscribe my channel by pressing the bell button. Don't forget to press the bell button, then my channel will be subscribed. You give your likes, you give your comments, and you give your suggestions. You subscribe my channel, then I am going to start with the next subject from next week onwards. Thank you.